by Karen Milner from Fort Harrison about the Paid Leave for All Workers Act. Before we turn it over to her, I do want to ask a couple of housekeeping things for everybody. Since we have over 50 people joining us through Zoom, we need you to please make sure that you are muted and have your camera off during this presentation. Whenever we move to the Members Matter portion, you are more than welcome to turn your camera back on and unmute yourself to participate. But during this, please ensure camera off and microphone muted. If you have any questions or issues, please use the chat. That will be monitored by staff during the presentation. And then also for attendance purposes, since we have so many people joining us this morning, which is wonderful, please make sure that your name through Zoom is either your full name or your first name and your library name. This makes it a lot easier for us to know who's attending with us today. So that really is all that I have to say as far as a welcome, and I'm going to go ahead and turn it over to Karen to present on the Paid Leave for All Workers Act.
Thank you, Kate. For those of you who don't know me, my name's Karen Milner. I'm an attorney with Fort Harrison in the St. Louis office, and our firm does primarily employment and labor work on behalf of employers, and we have our clients in the St. Louis office are pretty well split between Missouri and Illinois. So while Missouri remains pretty quiet on the employment law front and not a whole lot going on there at all, Illinois, as all of you know, is becoming the new California because Illinois continues to pass laws and take actions that make the state much more friendly for employees and much less favorable for employers. And this Paid Leave for All Workers Act is just another trip toward being more like California, I guess. So it was sort of unexpected that this law passed. According to Kimberly Ross is one of the attorneys in our Chicago office and follows legislation, state legislation, very, very carefully, and had indicated to me, because I wasn't following it very closely, but the legislation had been sitting sort of dormant for a while, and then all of a sudden Governor Pritzker signed it. And so now the law itself, the Paid Leave for All Workers Act, what we call the PLAW Act, Paid Leave for All Workers, is going to take effect on January 1st, 2024. So it's very, very important that everyone understand what the obligations are under the law and make sure that you are now getting your policies, your employee handbook, vacation or PTO policy up to date to ensure that you're going to be in compliance with it beginning on January 1 of 2024. And the thing that it makes it a little bit difficult, you'll see as I go through some of the definitions and some of the other pieces of the law, it would be really great if the Illinois Department of Labor would issue regulations to kind of flesh out some of the things that we don't necessarily know exactly what they mean. There's some contradictions, but so it takes effect January 1 of 2024. And the thing that's different about it is it requires leave to be allowed for any reason. And this is different. There are a lot of states that have mandatory paid sick leave, but this law says the employee can take it for any reason. It allows employees essentially to have 40 hours of paid leave per year. So many of our clients, they already have in place 40 hours of paid time off, whether it's referred to as vacation, PTO, and you're not going, if you're in that category, you're not going to have to give them employees anything more. The 40 hours of paid time off each year is what they're allowed to have, but you probably are going to have to relax some of your record keeping requirements. You can't, one of the things is you can't mandate that the employee tell you why they're taking the time off. You can't tell them that they have to submit or request in writing a month and a half ahead of time, and we'll kind of go through those things. But you're not going to have additional time off, paid time off budgeted if every employee is getting 40 hours. And the two ways you can do it are to front load it at the beginning of, if you use the anniversary year, if you use the calendar year, if you're going to put 40 hours into everyone's bank at the beginning, that's the front loading, that's completely fine. And if you do it that way, you do not have to allow them to carry it over into the next year. If you're using anniversary year, you tell the employees you have 40 hours of paid time to use as you see fit. You have to use it by your next anniversary date, or you're going to lose it. That's completely fine. And again, no additional leave is going to be required if you provide everyone with 40 hours of paid time off each year. The definition of employer is going to be if you have even at least one employee in Illinois, at school districts, that's one of the carve-outs. Carve-outs is federal government employees, school districts that are organized under the Illinois School Code, park districts organized under the Illinois Park District Code. And it may be possible even that the law is going to be applied to out-of-state employers. So a Missouri employer who has an employee who works in Illinois, it's just not really super clear yet, because it says if you have an employee in Illinois, it's possible that employers who really are based in another state may have to comply with the law for employees who are working in Illinois. It's sort of unknown at this time. Yeah, things aren't really all that simple. It also exempts employers that are covered by, this is an important point, if the employer is actually covered by a municipal or county ordinance in effect as of January 1, 2024, that requires employers to give paid leave already to their employees, paid sick time, paid leave. So in Chicago, and I'm definitely not the expert on the Chicago law, but I know that the Chicago law requires ordinances require some paid leave time. Again, Kimberly Ross is the expert on that, but my understanding is that requires 5 days of paid time off. And within Cook County, though, there are some municipalities that have elected out and said that municipalities have said, we're not going to follow the requirements of the Cook County ordinance. So if you're an employer in one of those municipalities, the PLAW leave is going to apply to you. But if you're already providing paid leave to the extent required under the Cook County ordinance, then you're not going to have to worry about this. The leave, like I said, it can be taken for any reason. You don't have to be sick. And the Chicago or the Cook County ordinance allows employers to ask for documentation if the employee is taking more than 3 days of leave. There are requirements with regard to the carryover. And this is important. The Cook County ordinance requires the employer to allow the employee, a new employee, to start using that leave time after 180 days of employment. The paid leave for all workers, you have to allow a new employee to begin using this paid time off after just 90 days of employment. And the new law, the PLAW leave, does not allow an employer to require an employee to use more than 2 hours at a time. So if the employee says, I only need 1 hour of time for my PLAW leave tomorrow, and I'm not going to tell you what it's You can ask the employee, actually, I think there's a slide in here that says you can't ask the employee. You can ask, but they don't have to tell you. They don't have to tell you why they're taking the time off. But if the employee says, I only need 1 hour of time, and that's all I want to take, you can, in your policy that you draft, you can say that it has to be used in a minimum of 2-hour increments. So that's one difference. The law, like I said, the employer can ask, what are you taking the time for? But the employee doesn't need to tell you that it's because I'm sick, or because I'm taking my kids to Six Flags, or whatever the case may be. And if well, we're going to get to the carryover. The carryover requirement is different if you front load the time and tell each employee you have 40 hours of paid time off to take this year, or the other alternative is to accrue it. If you accrue it and don't front load it, the employee simply earns 1 hour of PLAW leave for each 40 hours worked, but only the maximum you have to do is 40 hours each year. And then they have the definition of employee that essentially includes anyone working in the state of Illinois. They took the definition in the actual statute itself. They took the definition of employee from the Illinois Wage Payment and Collection Act. I'm sure you're all very familiar with that as well. And there are certain exceptions to this. The Illinois Wage Payment and Collection Act excludes domestic workers, but the PLAW leave says domestic workers. So anyone that you have that cleans the house, anything along those lines, is going to be covered. Just there's a few others that you can see on the slide. The PLAW leave does not apply to independent contractors. Of course, they're not employees, but the really big thing, and many of our clients, their employee handbook, their vacation policy, vacation time is only available to full-time employees. That's what they've had in the past. So one sort of new thing that affects a lot of Illinois employers, many employers did not in the past offer any type of paid time off for part-time employees. And because it's the paid leave for all workers law, that includes part-time employees, they are included as well. And so for the part-time employees, you can give them 40 hours up front, or something that most employers seem to want to do. It seems a little bit more fair, I guess, because the part-time employees are in fact working part-time, is to have them to have two tiers in your employee handbook. To have this applies to full-time employees, go ahead and front load that, but our part-time employees are in a separate bucket. The part-time employees are simply going to earn 1 hour of PLAW leave for every 40 hours worked. That's, clearly an alternative. And there are some other sort of minor things. College students who work part-time on a temporary basis for college, they don't have to be paid. They're not eligible for PLAW leave. And then I'm going to talk a little bit about employees who are covered by collective bargaining agreements and things that you really need to keep in mind when when the collective bargaining agreement expires moving forward. And a couple of those, one of them that's really important is if an individual is a construction worker, construction workers who are covered by a collective bargaining agreement, they're not going to need to be provided. They're not going to be covered under the law. And also employers that provide pickup and transport of parcels of documents, courier service, and who move freight. If they're covered by a CBA, they're not going to be covered either. And this is where we get into the possibility that an employer who's completely located in Missouri or Indiana, but has an employee who works in Illinois, arguably, even if it's a remote employee whose job site, actual office is in St. Louis or office in Indiana. But the employee lives in Illinois, works from home. An employer in these other states is going to have to take into consideration that this employee who's working from home in Illinois, or going repeatedly to maybe a customer or client in Illinois, that person may also need to have available to him or her the paid leave that's required under the PLAW Act. So if an employee attends meetings, conferences, trade shows, the remote work is mentioned in here, and maybe somebody who travels through Illinois, we just don't have any. Usually when the regulations are issued, they will provide some clarity to these things that sort of appear to be kind of open questions. If an employee lives and works in another state, then he goes over for a conference. What is the employer going to do? If it's really sort of limited contact with the state of Illinois, it sure seems that doing the accrual would be better. Is the employer going to be able to say, oh, this person works this number of hours, 40 hours a year in Illinois, so I'm going to give him one paid hour for each 40 hours that he works in Illinois? We just don't know sitting here today exactly how those situations are going to be when the employee just works on a part-time basis or a temporary basis in the state of Illinois. We just don't have anything to tell us yet. But it would be important, just because that's a possibility for any employer who has people who work in Illinois, to make sure that those hours that they're working in Illinois are tracked, because we don't know how that's going to come out. Who else could possibly be an employee? And again, the PLAW Act draws a lot from the Illinois Wage Payment and Collection Act. The Illinois Wage Payment and Collection Act, of course, has been around since, I believe, the 1980s, or at least early 90s. And those regulations indicate that the Illinois Department of Labor, in enforcing the Illinois Wage Payment and Collection Act, could assert jurisdiction over a claim if the work is performed outside of the state of Illinois, but the employer is located in Illinois. So again, if you're an employer located in the state of Illinois, but your actual employee's job site is over in Missouri, in Indiana, in some other state, then is the Illinois employer required to accrue the leave, or provide those employees with the 40 hours up front, whichever the employer decides to do? I don't know. We just don't know. So it may actually apply to out-of-state employers that have employees performing any work in Illinois, may apply to in-state employers that with employees who solely work outside of Illinois. Illinois tends to want to cover everyone and everything when it's something that is a law that is beneficial to employees. So there's a good possibility that all of the takeaways that all of these employers may have to comply to some degree or another with the law. Let's see. I mentioned just real quickly, just a little bit about employees who are covered by a collective bargaining agreement. So it isn't going to, if your collective bargaining agreement is in effect now or prior to 1/1/24, you're not going to have to change the collective bargaining agreement now. But moving forward, if the employer and the union don't want to have to, the union's agreeing we're not going, the PLAW Act, the employer doesn't have to comply with that because presumably whatever's in the collective bargaining agreement is more favorable to the employees in terms of the time off. So you're gonna have to remember when you bargain the agreement in the future, excuse me, you need to make sure that the collective bargaining agreement states in very, very clear and unambiguous terms that the parties are, the employers is not, we're waiving the requirements of the PLAW Act. You need to make sure that that language is in there. If you're right now in the middle of contract negotiations, you want to make sure that this is something that is mentioned so that at the table, so that you have a provision in there that sets forth explicitly that you're not, the PLAW Act is not going to be applicable to this unit. Also, it doesn't apply to this, I just mentioned a minute ago, state agency employers. It's not going to apply to them if there's a collective bargaining agreement. Construction workers, like I mentioned, the law just doesn't apply to them. And then the employers who are parcel services, or I guess couriers, more commonly referred to as courier services. So mentioned it real quickly, but this next slide is going to tell us how much paid time and how much paid time off and how is it earned. So the employer can do either, as I mentioned up front, and you can use a calendar year, you can use the employee's anniversary year. If there's some other 12-month period that is meaningful, the fiscal year, whatever that happens to be. So you need to pick that. And generally what clients are doing that I'm seeing is to simply, they already have a vacation pay policy or something else in place that uses anniversary year or uses calendar year. So just, you can go with that. And there are certain repercussions of using the front loading or the accrual method. I'll talk about in a second. So, exempt employees who are exempt under the FLSA, the presumption is that they work 40 hours a week, unless there's something to show it's not 40 hours a week. Again, front loading, even for part-time employees, has to be the 40 hours, which is why many employers, I would think, would want to, for part-time employees, instead do the accrual method, which is the 1 hour for every 40 hours worked. And this next slide talks about kind of some of the differences between front loading and the accrual method. So the front loading, of course, is going to make the whole 40 hours be available at once. But if the employer front loads, you do not have to carry it over. You state specifically in your policy that the employee must take it during the applicable 12-month period, the anniversary year, the calendar year. And again, after 90 days of employment, the employee then has the right to start using the available PLAW leave. Let's see. And this, again, if it's part-time employees and you're doing the accrual method, it doesn't have to be the whole 40 hours. It's just 1 hour for each 40 hours worked. And what I have found, which is good, is there's most companies that are of any size are in fact already providing 40 hours of paid time off. So there's not going to be a budgetary impact by this law, but there are some other impacts that we'll talk about. Oh, and you have to stay consistent. If whatever your yearly, your 12-month period is, you need to just keep that and not change it. If you are going to change from anniversary year to calendar year, you're going to have to notify employees in writing ahead of time what's going to be changing. If there's any, if the anniversary year is pretty clear because, and you need to kind of build other things in if the law goes into effect on January 1, 2024, that's when it is going to go into effect. Again, the employees, you can start it then, or if it's a period other than the anniversary date, you're going to have to provide a pro rata amount as soon as the law goes into effect. Again, 2 hours, you can have them wait 90 days to begin using it, but it needs to be in their bank at the beginning of whatever the 12-month period is. So again, an employee can use it for any reason at all. And then there's another sort of aspect of your policy that you need to take into consideration, and there are ramifications depending on how you choose to do it. So if you have, for employees, if you have a PLAW bank, it's just the required PLAW leave, and then over here on the other side you have vacation and or PTO. So if it's all in one bucket, then number one, the employees, if you have it separate, that's separate, and they use the PLAW leave when they don't want to tell you why they're taking the time off, which most employees don't. That seems kind of a silly thing, but maybe they don't want to tell you, and it's completely fine. So if you can have that PLAW bank, and then over here you have their regular PTO or vacation that's over and above the PLAW leave. For the PLAW leave itself, you can ask the employee to provide 7 calendar days notice. If that's what you do for vacations and PTO, no problem at all. But 2 things. Number one is if the employee's need for the time off is not foreseeable because the dog got sick and he's going to have to take the time off right away. If it's not practical for them to give advance notice, they don't have to give advance notice. And you can't require them to provide you with a note from the veterinarian or the school or whatever it was the employee was taking the time off for. So while you can ask for the 7 calendar days notice, again, the employee can say, nope, got to take it off. They just have to give you as much notice as possible. Then, you also, at the very end, I'll talk about, which you all know, you can't retaliate against somebody for exercising their rights under the PLAW Act. So if you ding them with an attendance policy violation, that's going to look like retaliation. So, and they can take it, obviously, if their FMLA is over, maybe then they're going to say, well, I need 40 more hours to an additional week off. They might put that on to the end of their FMLA leave. Probably you could use the time as an argument that you're providing the individual with a reasonable accommodation. There are a lot of things to take into account. And this is going to talk about the carryover. So if the employer front loads the 40 hours, you don't have to carry it over. If you use the accrual method, then all unused time has to carry over to the next year. But here's the thing. The law, the Paid Leave for All Workers law, says that the total amount that you have to give in every 12 months is 40 hours. So if the employee never uses his PLAW leave, the law, and you're using accrual, the law says you have to allow the employee it all carries over. But if you're doing it this way, you still have the right to say, well, you can only take 40 hours of this paid time in this 12-month period. So to me, that's a little bit confusing as well. And if the employer combines the PLAW leave with other forms of leave, it's all in the PTO bank, then you go back to the rules that you've been following for years, which is if you have a use it or lose it policy, that's going to be fine for you to include that and use it or lose it. And then the other aspect of this where there's maybe a little bit of confusion is payout upon separation. So they did think about it in this legislation, and said that if you have your PLAW Act leave in one bank over here, and in the employee's other bank over here, you have vacation or PTO, you all know under the Illinois Wage Payment Collection Act that when an employee quits or gets fired, they get under the Illinois Wage Payment Collection Act, they get all of their unused accrued paid time off, vacation. So if it's all in one bank, then you're going to have to, the PLAW Act leave will be included in there, and you have to pay it to them upon separation. But if you have it in the PLAW Act leave time in a separate bank, then you will not have to pay that upon separation. But there's one quirk, I think it's in one of the later slides. If the employee, if that's the situation you have, you didn't pay out any PLAW Act leave upon separation because you keep it in the separate bank, and the employee quits, and then within 12 months he comes back to work, he's going to have to be credited in his bank with whatever he hadn't used when he left. So some good reasons for the separate banks of leave is if it's combined, you're going to have to pay all of it around at the time of termination. It's also more difficult record keeping if you because you're going to have to ask employees which bank of time do you want this deducted from. And I guess we have to wait for the regulations, but if we do put it all into one bank, there's a possibility that you wouldn't then be able to ask the employee for the reasons for time outside of the PLAW Act leave. If it's all in one bank, I don't think that's going to be the case, but we have to wait for the regulations on a lot of these. Combined banks, easier to manage time off, and may limit payout of unused time upon termination. Oh, and this is what I just mentioned a second ago. If the employee is terminated or resigns and is rehired within 12 months, it's just a lot of record keeping that everybody is going to, everyone's gonna have to kind of go through. It's an employee, we said that the employer can't, the employer is allowed to ask why the employee is taking PLAW leave, but the employee doesn't have to tell you. And so, I mean, there's a chance, a very, very remote chance, I would say, that the Illinois Department of Labor could possibly, if it's all in one bank, could possibly say, oh, well, now you can't ask the individual for a reason for taking any time off. I don't think that's going to happen, but we don't know. So the record keeping requirements, and then I'm going to talk just a little bit about the penalties, because everyone's interested in the penalties because you to know what you're getting into. First is the poster. When I started practicing law many years ago, the workplace poster was a 3-in-1 poster. It quickly became a 7-in-1 poster, and now in Illinois, probably a 30-in-1 poster. Many posters that you have to put up. So the Illinois Department of Labor, I am extremely confident that they will publish the poster that needs to be posted, the information that needs to be posted for employers at each work site. And it has to be posted in a conspicuous place where both applicants and employees can see it, just like all of your EEO poster, your Illinois Workers' Comp poster, Illinois Department of Human Rights poster, all of those things. And that will, again, I'm certain the Illinois Department of Labor will publish the poster, make it available. It will include information about how to file a charge with the Illinois Department of Labor if the employee believes that the employer is violating the PLAW Leave Act. And that will be in English and Spanish and whatever other languages I suppose that they're going to have. Notice to employees has to also be given when they start employment. The most, I guess, efficient way to do that is your employee handbook that you have that you give to all new employees. Just go to your policy on, if you have, some have sick day policy, then a vacation policy, then maybe some personal days. Think about maybe combining everything into one, or at minimum having your PLAW Act leave here. And again, especially if you have a lot of part-time employees, that may make the most sense to do the accrual method. Anyway, your employee handbook is really the best way to provide the notice to employees upon commencement of employment. Make sure that you get your handbooks out and start dusting off those specific policies. And more record keeping for you. Create and preserve records documenting hours worked, how much paid leave is accrued and taken, or if you're using the loading method, how much was put into each employee's bank. And again, you can require that they wait 90 days to calendar days after employment to actually take any. Just make sure it's just more record keeping for you. So the statute of limitations is going to be 3 years. So the Illinois Department of Labor, if they come in and they conduct an audit, you have to have those records and allow them to see those. And the Illinois Wage Payment and Collection Act requires employers to track hours of all employees, and that does include the exempt employees. I know that's a sort of a big issue a lot, because most of the salaried exempt employees are not clocking in, clocking out. So this is really an issue that is outside of the PLAW Act, but a good way to keep some sort of record for exempt employees would be to have them at least have a sign in and sign out sheet. And again, that's separate from the new law. And non-compliance, what can that get you? What kind of penalties are we talking about? Again, 3-year statute of limitations, like most Illinois laws, not the biometric privacy law, but that's a completely different rough topic. If there's a violation, then an administrative law judge with the Illinois Department of Labor will hold a formal hearing, and some of the other statutory penalties are up to $1,000 in civil penalties to affected employees. If anybody should have had the paid leave available to them and they didn't, that would be something that the amount, the 40 hours times their regular rate of pay would be an actual underpayment. Equitable relief would include a mandate in order that the employer begin to comply with PLAW if it wasn't doing that before. And of course, attorney's fees, many times the attorney's fees are higher than what the judgment is. Anyway, and then there's also a separate statutory penalty in the law itself of $2,500 up to that amount for each separate violation. And that money goes into a paid leave for all workers fund. So Illinois always gets us somehow, especially on the speeding tickets. There, as I mentioned, and would be no surprise, non-retaliation provision. You can't, and this is with every Illinois employment law, can't threaten to take adverse action, can't take adverse action against someone who either takes leave under the PLAW Act, somebody who goes to the employer and says, hey, there's this new law that took effect January 1 of 2024 and you're not complying with it. And then also possible regular cause of action for retaliatory discharge would result in damages against the employer. I had a client just earlier this week who we're revising the policy in the employee handbook to include this. And she mentioned, the HR person mentioned that she had heard a number of employees just talking amongst themselves saying, oh, we're going to get 40 more hours of vacation next year. And that, I guess she heard about the law, but that particular employer already provides people with 40 hours each year. And the steps, sort of the final takeaways. If you are in Cook County, and if you are, again, in a municipality that has adopted or has not opted out of the Chicago or the Cook County ordinance with regard to sick pay, you don't need to do anything because you're already having to comply with that. But there may be changes later this year. We don't have much time left in the year, but that may happen. So really just especially look at your policy. If you don't have an employee handbook that includes your vacation or PTO policy, if you have a separate policy, make sure that you have that reviewed before 1/1 of 24. You don't want it to be January 1st, 2024. And you say, wait, what happened? We need to get this in place. So you want to do it now or do it in the next couple of months. And you're going to have to make decisions then. Do we want to front load or do we want to accrue? And we talked about the differences there. Accrual, you have to allow the carryover. Front load, you don't. And if you have the separate banks, then if you keep them separate, when employees terminate, you don't have to give them whatever they have left in their PLAW leave bank. But of course, PTO and vacation, you have to give to them under the Illinois Wage Payment Collection Act, which is separate. If you have collective bargaining agreements, you have unions, just make sure that that's something that you specifically address. If everyone's in agreement, if the union's in agreement, the employer's in agreement, that we have a really good, the employees already have a good paid time off provision in the CBA. We don't need to do this. Make sure that you know and that you do include very, very explicit language to say we're not going to be the employer doesn't have to comply with the PLAW Act, and maybe here's why. So we will probably have some amendments to the Chicago ordinance, Cook County ordinance later in 2023. But again, we're sort of a little bit running out of time here. We'll see. I haven't heard anything about that yet. And then also whatever systems you have to keep track of employee time, just make sure that up at least as of January 1 of 2024, that you have that in place and are able to keep track of all that. And I think that was it, but I am more than happy to try to answer any questions that anyone has.
Thank you.
Kate, are you gonna?
Okay.
Sorry.
Thank you so much, Karen. My colleague Sarah has been monitoring the chat, so she's going to ask some of the questions that have come in, and we'll thank you again. Yeah.
Hello.
Were there any questions, Sarah? Should I click on the chat? I'm sorry. Should I click on the chat? I don't. Hey.
Oh, sorry about that. We are figuring out how to not echo Sarah.
Keep that on.
Okay.
Okay, now it should work better.
Sorry about that. Yeah, we do have quite a few questions. So for part-time workers, can we front load with 20 hours as long as it is equal to or more than they would earn in time off?
Well, that's an interesting question, and I'll look at that and I'll send an email. But my recollection is that it has to, if you're going to front load for part-time workers, it has to be the full 40 hours. I'm looking here real quick to see. I believe that if it's a part-time employee and you're going to front load, then it has to be 40 hours. But I will check that and I'll send an email to Kate later today that she can circulate. I'm 90% certain if you're going to front load for part-time employees, it has to be 40 hours. But I'll check and send an email.
Thank you.
And
Is
if-
there so sorry.
I'm sorry.
Is there a limit to the amount of hours accrued?
No, there's no limit to the amount of hours accrued. So if somebody's working 100 hours a week, I guess, and so what they have to have if you're using the accrual method is 1 hour for each 40 hours of work. But all you have to give the employee, all you have to allow them to take off under the law is no matter if you're using the accrual method and you go and the person accrues 100 hours, it doesn't matter because you only have to allow them to take 40 hours of paid time each year, and your year is whatever you've chosen, the calendar year, anniversary year. 40 hours is all you have to allow them to take, if that makes sense.
If HR is made aware that the leave is due to a medical reason, can PLAW hours run concurrently with FMLA? Legally, how do we determine what leave should be triggered?
Okay, I'm sorry, I don't think it was addressed in here. If the employee has a bank of PLAW time and a bank of vacation or sick time, it's the employee's choice as to whether he wants his 2 hours of being sick. He wants that or whatever many hours it is, he can choose, the employee can choose if he's got his PLAW leave time over here that he wants these 8 hours to apply to his PLAW leave. And then in answer to the question as to whether if you know the reason the person is off work, even though he said I'm taking PLAW time off, if the employer knows somehow that he's doing something that is covered under the FMLA, there isn't anything in the paid leave for all workers law that says, oh, and this is how it interacts with FMLA. This is how it's just not, there's nothing in there that says that. So I would, until there's some regulation to the contrary, if I know that my employee is taking his 40 hours of time off next week because he's going in for arm surgery or some whatever, he's going to be in the hospital for some sort of surgery, I don't think there would be anything inconsistent with either state law or federal law to go ahead and designate that 40 hours, even though it's his PLAW leave. If we know it's a FEMLA qualifying reason, I don't see anything anywhere that's going to prevent the employer from saying, okay, Henry, we know that you went in for your toe surgery, and so we're going to go ahead and designate that week as an FMLA week for you. I don't see anything that would preclude an employer from doing that. I hope I answered that.
If we are closed for holidays or inclement weather, we are not paid for those hours. Can employees request PTO funds to cover those days?
I would say no, because if those, well, wait a minute, if the days the employer's closed because there's a big snowstorm, if the employer allows people in that situation, if they have vacation or PTO in their bank over here that we've already been giving them, then yes, the person over here who has the PLAW leave should be able to take those 2 out. You're going to open 2 hours late, they should be able to take that time out of their PLAW leave bank if you allow other employees to take vacation or PTO. If you don't do that, if the employer says, we're closed tomorrow, sorry guys, and there's nobody's working, then that's not really time. It's not time off because you're telling everybody to stay home. So if the employer in that situation says no pay for anyone, arguably this guy is the PLAW leave person isn't taking time off because I would say no. If the employer doesn't allow other employees to use PTO or vacation time, I would say no. It's because the person isn't taking time off in that situation. He's ordered not to come to work. So that would kind of, if you move into thinking about if your place is closed normally on Saturday and Sunday, I don't think an employee could say, okay, well, I want I want PLAW leave for Saturday because he doesn't work on Saturdays because the place is closed. So that would be what I would say. That only if you're closed due to bad weather, if you allow other people to take vacation time, okay, then I would think that he would have a very good argument that he should be able to use the PLAW leave too. But
Yeah.
if not, then no.
Karen, can I interrupt? This is Jill. I have a question kind of going back to your family medical leave question, or the family medical leave question that was before. So if our policy in our handbook designates that they must take off all paid time off leave while on family medical leave, that will pertain to PLAW as well, or can I not make them take PLAW when they're on a family medical leave?
And that's a good question. I'm gonna answer that on email too. So so if an employee is taking FEMLA for whatever reason, instead of allowing them at the outset to have it as an unpaid leave, if they have vacation time in their bank, you say, hey, you have to use this when you're on FMLA. And so your question is, would that apply as well to PLAW leave? That would be one of the things the person has in their bank that we're going to require them to take off.
Correct. Yeah.
Yeah,
Can I
I'll answer that
require
later.
them to use the PLAW leave? That's the biggest question
Yeah.
for an FMLA qualifying event.
Okay, I'm gonna see if there's anything. I have the statute right here in front of me, and it's not too long, but I'll put that in an email, as well as the question about part-time employees. Do they need 40 hours loaded? I'll put that in the email, and Jill, I'll send it to you and to Kate. I'll just send it to both of you, and so you guys can get it to the attendees.
Okay, thank you.
Yeah, I don't know if I'll have an answer, but I'll give you what I think the answer will be, because I didn't think there was anything in the state statute itself that got into that much detail, but I'll answer both of those in an email.
Karen, we have just a few more minutes. Sarah, how many questions do we have?
There are 6 more questions.
There are 6 more questions that we have. Do we have time for those, or what works for you, Karen?
Oh, yeah, I can answer them, or you can send them to me and I can answer them in an email. Whatever you prefer is fine, either way.
Okay, let's see if we can, there might be some that can be answered quickly, so.
This one should be pretty.
Sounds good.
Is there an age limit on this? Do our high school kids get in on this?
Yeah. Oh, yeah. There's no age limit. There's nothing like that. There's just a few carve outs. One of them had to do with college students, but no, it applies. If it's a 16-year-old kid who's working in the summer, he gets it.
So this does not apply to part-time employees.
Yes, it absolutely applies to part-time employees.
Okay.
If an employee is scheduled for 10 hours a week, it is possible for them to take 4 weeks off in a row if needed. Is that correct?
4 weeks? I'm sorry. The statute only requires the employer to provide 40 hours each year. You're using the calendar year, if you're using the anniversary year, whatever 12 months you're using, it's just 40 hours. So did I not answer that question?
I think that does. Yeah, if they're scheduled only for 10 hours a week, is it possible for them to take 4 weeks in a row? So yes. Will sick time be the same as PLAW? Is there a maximum if we have to carry over each year?
So here's your sick time is whatever that policy happens to be. If you have sick time in terms of carryover or not carryover, the employer has the right to say that in Illinois, a use it or lose it policy with regard to that. So that's what your sick policy says. The PLAW leave, the law requires if you're going to accrue 1 hour for each 40 hours worked, then you do have whatever the person has left, you do have to carry over into the next 12-month period, calendar year, anniversary year, whatever you're using. But at the same time, the law only requires the excuse me, the employer to allow the employee to have 40 hours each 12-month period as PLAW leave. So, and if you front load PLAW leave, there's no carryover. If you front load, everybody just gets 40 hours each year. There's no carryover requirement.
Thank you. If they have accrued PLAW hours, do we pay out all of that at time of severance?
Oh, I'm sorry. At time of severance, if the employer keeps PLAW leave in one bank and has other paid time in another bank, you do not have to pay for any available PLAW leave at the time of separation. You don't have to pay it at all. On the other hand, if the PLAW leave, the 40 hours is built into or made part of a pot that is just like a, say, PTO. PTO, everybody gets 80 hours of PTO each calendar year, but 40 of that counts toward PLAW leave. 40 hours of that 80 is considered PLAW leave. If that's how you do it, it's all in that one bank together, then you do have to pay it out at the time of separation, and that's PLAW leave. And at the same time, it's Illinois Wage Payment and Collection Act that's going to require that.
Karen, can I elaborate on that too? You had mentioned about having the two different tiers, that it would be good to upfront folks 40 hours for full-time, and then for part-time do the 1 hour for every 40 worked. So is that going to affect the payout at termination? Would I still be required then to pay out the part-time folks and not the full-time because I front loaded full-time and I accrued part-time?
Yes.
Okay, that's what I thought.
If you are accruing, if you're accruing, and it seems like a good way to do that, just because you don't, especially if the people are very part-time. I don't know that you want to load them up at the beginning of the year with 40 hours. But it's really up to the employer. But yeah, you do have to pay out. If you're going to use the accrual method, you have to pay out upon separation. So that would be true for the part-time employee.
Thank you.
Sure.
You actually just answered the last question, so that's it for the questions. Thank you.
Okay. And so I'll answer the other two. I'm going to make sure that 40 hours for the part-time is the front-loaded amount. I'm 90% sure it is, but I'll send that in an email, and then I'll try to answer your question as well, Jill, about getting.
Great. Can I ask one more question? I'm so sorry. So
Sure.
if our period goes from our fiscal year, which is 7/1 to 6/30, on 7/1, we already gave folks what we deem right now as personal leave, but we're going to change that to the PLAW leave. Do I have to then January 1 give another bank, or can I just say our personal leave is now designated as PLAW leave? Does that make sense?
Yes, as of 1/1/24, that's what you want to say. Okay, you call it personal leave. Sitting here today, it's called personal leave, and say it's 40 hours a year for each person. So yeah, as of 1/1/24, you definitely want, or you can even do it now or whatever. But anyway, yeah, you definitely want to say, hey, everybody, you're all aware that you have 40 hours of personal leave to use each fiscal year. So guess what? Now it's not called personal leave anymore. Now it's called, or it's, you don't even can draft around it. But anyway, to say, please be advised that as of 1/1/24, the 40 hours will be considered leave or to comply with our leave obligations under the Paid Leave for All Workers Act. And so here's a little bit different rules for it. So for example, if your personal leave policy says everybody has to give you 10 days advance notice of the need for the time off, and you have to take full days off, we're going to have to change those little parameters to be compliant with the PLAW leave, to say 2-hour minimum, and to say if you can't provide us, if it's not reasonable to provide us with advance notice, then you can take it, give us as much notice as practical. All those little things that are required by PLAW, that's what you'll do.
Okay,
It
but I don't have to give them any
provides the policy.
additional, I don't have to give them any additional hours, because what if I gave it to them 7/1, they took it 8/1 of 2023, but the law doesn't go into effect until January 1 of 2024? Does that make sense?
Yeah, yeah, I know, I see what you're saying, but I would have to look at that more. The safe thing obviously is to say, as of January 1, 2024, you get 40 hours of PLAW leave, but I see what you're saying, that you gave it to them 40 hours on July 1 of 2023, and they may already have taken that all by January 1 of 2024. So I'd have
Yeah.
to look at that specific issue.
Okay, thank you so much.
Yeah, no problem.
Okay, I know that this
If
is
anybody
being
else-
recorded. Oh, Karen, this is being recorded, so we will put this on our YouTube page. We did have a question earlier. Will your slideshow be able to be shared with our attendees?
Oh, sure. I don't know how to do that, but yeah, feel free. For sure. Yeah, everybody can have a copy.
You sent it to me, so I've got that, so I can handle that part. And then I think we had one very last question that was on the minds of a couple of people. And then again, thank you so much for your time. We'll ask this question and then we'll let you get on with your day.
Okay.
For part-time employees, do they still get 1 hour for 40, or do they get 1 hour for the hours they work for the week?
As a part-time employee works, once they have actually physically worked 40 hours, you put 1 hour of PLAW time in their bank. They work another 40 hours, you put another hour of PLAW time in their bank, so on and so forth. But just up to, and the maximum is 40 hours each year. Does that make sense?
Yes. Well, thank you so much. This was very informative and we appreciate that you'll let us share the slides and follow up with those questions that we weren't able to answer during our time now. I'm going to go ahead and start my video again. Okay, so we are going to take just a minute to move over to our members matter portion. Karen, thank you again so much for joining us and have a great rest of your day.
Thank you very much.
Okay, everyone, well, we are here. It is 11:08. We are here at Huron City Library, and we can see who you all are since we have your names on Zoom. But now we will let you know who's all here in the room with us.